Forever grateful. Thank you, Madam President. I yield the floor.
Madam President.
Senator from Minnesota.
Madam President, I come to the floor today because there are three extremely talented, well-qualified women nominees who are ready to get to work on the United States Court of Appeals for the D.C. Circuit. It's time they are confirmed. I'll be joined this afternoon by several of our colleagues, Senators Hirono, Cantwell, Kaine, and Blumenthal, because we all know that it's time for the Senate to stop the needless blocking of these women. Enough is enough. And I want to thank Chairman Leahy for his persistence and the fact that we are not giving up on these three qualified women for the bench. Our courts need judges in order for the third branch of our government to function. The Senate should not be shutting down another branch of government. Some of my colleagues in the Senate won't even allow an up or down vote on these nominees. I don't know if they've even met these nominees, but if they met these nominees, I don't know how they could come to this floor and not allow an up or down vote. President George W. Bush's candidates to the D.C. Circuit were confirmed so that the D.C. Circuit could keep running, and our current president's nominees should be considered in the same manner. You can't have justice with an empty courtroom. It's time to stop making excuses. It's time to put judges in their courtrooms, and it's time to get these women on the bench. One of the very well-qualified nominees is Nina Pillard. Nina Pillard is a talented lawyer and professor. She's the kind of sensible, well-respected person who we need to fill one of those empty seats in that courtroom. Actually, it's Professor Pillard because she's been a law professor at the Georgetown University Law Center for the last 15 years. She graduated magna cum laude from Yale College in 1983 and earned her J.D. from Harvard Law School in 1987, again graduating with honors. In addition to her academic career, Ms. Pillard served in government. From 1998 to 2000, she was a Deputy Assistant Attorney General for the Justice Department's Office of Legal Counsel. Prior to that, she served as an assistant to the Solicitor General, a position held by some of our country's most talented lawyers. It should be no surprise that Ms. Pillard is one of the most accomplished Supreme Court advocates in the nation. She has argued 9 cases before our nation's highest court and has briefed 25 cases. Outside the courtroom, she has spent her time teaching and mentoring young lawyers, serving as the faculty director for Georgetown Law School Supreme Court Institute. When the current Supreme Court Justice Alito was nominated by President Bush to fill an open seat on the Supreme Court, Ms. Pillard also donated her time to the committee to help review his writings and make a recommendation on his qualifications. Why? She was the chair of the American Bar Association Reading Committee at Georgetown Law Center, which found Justice Alito well qualified to sit on the Supreme Court. People across the aisle think that Ms. Pillard is well qualified too. The head of the Justice Department's Office of Legal Policy under President Bush said that Ms. Pillard is a patient and unbiased listener, a lawyer of great judgment and unquestioned integrity. The deans of 25 law schools, including the University of New Hampshire, the University of Arizona, and the University of Maine, wrote that Ms. Pillard has shown an appreciation of nuance and respect for opposing viewpoints, grounded in a profound commitment to fair process and fidelity to the law. 25 more former federal prosecutors and law enforcement officials said that Ms. Pillard is unquestionably eminently qualified and is a sensible and fair-minded lawyer. And the nonpartisan American Bar Association, this is no surprise, the committee that reviews every federal judicial nominee, unanimously gave Ms. Pillard its highest possible rating. Fair-minded, unquestionably qualified, unquestioned integrity. These are the qualities the Senate should be looking for in a person we entrust to decide cases in our federal courts. Next week, the Senate should give Ms. Pillard an up or down vote. My hope for progress next week is in contrast to the reality we saw just 1 week ago when the Senate voted to block another eminently qualified woman to an up or down vote. As I stated last week on the floor, Patty Millett would also be an excellent person to fill one of the vacancies on the D.C. Court. My colleagues have discussed the qualifications of Ms. Millett at length. She's a talented lawyer with extensive appellate experience, 32 cases in front of the Supreme Court. I do not understand how anyone in good faith could vote to block an up or down vote of someone who has argued 32 cases in front of the U.S. Supreme Court, who has served as an Assistant Solicitor General, who spent 15 years as an attorney on the appellate staff of the U.S. Department of Justice Civil Division under both Democratic and Republican administrations. With all this experience, Ms. Millett is also one of the most experienced Supreme Court advocates in the nation. Just like Ms. Pillard, Ms. Millett also received the highest possible rating from the nonpartisan American Bar Association committee that reviews every federal judicial nominee. And she's done all of this, as we all have learned, while raising a family with a spouse, serving in the military overseas, raising 2 children while her husband was serving our country overseas, while donating her time to help kids learn how to read, volunteering for the homeless. How can anyone not allow for a vote on this nominee? This is another woman of unquestioned ability. Instead of confirming Ms. Millett last week, sadly, she was filibustered. Another woman filibustered, stopped in her tracks. Well, we are here today, and I see some of my colleagues have gotten to the floor, and before I talk about Caitlin Halligan, I'm going to give them an opportunity to speak. But another woman stopped in her tracks. This has to end. We have been making so much progress for women in the judicial system for women in the United States Senate. We are now 20 of 100 senators. No one filibustered us. We got to get an up or down vote when we came before the American people, win or lose. Well, how it works for judges is you should get an up or a down vote, and that's what these women deserve. With that, I'm going to turn it over to Senator Hirono from the state of Hawaii, also a member of the Judiciary Committee. I need to recognize
Madam President,
Senator from Hawaii.
I thank my colleague from Minnesota. I rise to speak in support of the nomination of Cornelia Nina Pillard to be a circuit judge for the United States Court of Appeals for the District of Columbia Circuit. Less than 2 weeks ago, my colleagues on the other side of the table blocked another nominee to the D.C. Circuit, Patty Millett. Earlier this year, they also blocked Caitlin Halligan, yet another woman who had been nominated to the D.C. Circuit. Unfortunately, Ms. Halligan withdrew her nomination after over 2 years of obstruction. Only 5 women have served as judges on the D.C. Circuit in its entire 120-year history. The D.C. Circuit is one of the most important circuits in our nation, and it is shameful that female perspectives are so underrepresented. Now the Senate will consider the nomination of Nina Pillard, a truly outstanding nominee to the federal bench. Ms. Pillard is currently a law professor at Georgetown University Law Center and is one of the leading appellate attorneys in this country. Professor Pillard has extensive litigation experience at all levels. She has argued 9 cases in the Supreme Court and has briefed dozens more, including the historic United States v. Virginia case that opened the Virginia Military Institute to women, and the Nevada Department of Human Resources v. Hibbs case that sustained the Family and Medical Leave Act against a constitutional challenge and ensured that a primary caregiver could take leave in the case of a family illness, regardless of gender, and in this case, the family caregiver was a male. Professor Pillard has also had an impressive 15-year tenure teaching constitutional law at Georgetown. And the fact that that is my alma mater has nothing to do with my support of her. In addition, she serves as co-director of the Georgetown Supreme Court Institute, where she prepares lawyers for oral argument before the U.S. Supreme Court on a pro bono basis, without regard to which side of the case they represent. In fact, under her leadership, the Supreme Court Institute prepared lawyers on one or both sides of every case heard by the justices in the 2012 term. Professor Pillard has also twice served as a top attorney at the U.S. Department of Justice, and in those roles, she advised and defended U.S. government agencies and officials on criminal law enforcement and national security matters. Invaluable experience for a judge on the D.C. Circuit where such issues are routinely considered. I have been deeply impressed with her experience and record and have found her to be exceptionally qualified for this important position in the D.C. Circuit. In addition to her extensive qualifications, Professor Pillard also has demonstrated a commitment to fair and impartial process throughout her career. As mentioned by my colleague, for example, when Professor Pillard chaired the ABA Reading Committee that reviewed Samuel Alito during his nomination process, her assessment of his legal record led the ABA to apply their highest rating of well-qualified. She deserves to be held to the same rigorous, fair standard. However, following Patty Millett and Caitlin Halligan, Nina Pillard is the third woman in a row to be nominated to the D.C. Circuit, only to face obstruction from my colleagues on the other side of the aisle. The D.C. Circuit is one of the most important courts in our nation, weighing key constitutional issues and other matters of federal law and regulation. But 3 of the 11 seats on this court stand vacant. Given the complexity and far-ranging impact of the cases the court hears, it is critical we fill vacancies without delay. Along with Patty Millett and Nina Pillard, President Obama has nominated Judge Robert Wilkins to fill these important vacancies. Unfortunately, so far, we have seen nothing but more obstruction of these extremely well-qualified nominees. This is an opportunity to put exceptionally talented lawyers on a significant court that has vacancies needing to be filled. I am disappointed that our colleagues recently blocked a vote to confirm Patty Millett, not only a great lawyer, but a military spouse who managed a successful career in the care of her children while her husband was deployed overseas. And when we talk about supporting our troops, it means supporting their very well-qualified spouses, such as Patty Millett. I was dismayed and saddened when obstruction caused Caitlin Halligan to give up on her nomination after 2 years. It would be disgraceful to continue this obstruction of these qualified and impressive women. I urge senators to reconsider and support these nominations. I yield the floor.
Madam President,
Senator from Minnesota.
we've also been joined by Senator Kaine of Virginia, who knows a little bit about one of these nominees and also is a strong advocate for more women in the legal profession. And that's one of the cases that we're making here today, that this is about the D.C. Circuit. This is about the repeated gridlock that we're seeing in Washington that I think the people of this country have said they've had enough of, but it also is about the fact that our colleagues on the other side of the aisle have now blocked not 1, not 2, but 3 incredibly qualified women. And we are starting small here on a Thursday afternoon when, well, maybe there's not a lot of people in the gallery, but this is just the beginning, and we are not going to let this go.
Senator from Virginia.
Madam President, I thank my colleagues, the Senator from Minnesota and the Senator from Hawaii, for joining me on the floor. This is a matter that I feel very strongly about, and I do want to offer a few words to basically just raise a question whether there is a double standard for appointment of women to this particular court, the D.C. Circuit. But before I tackle that question, I will just say one thing, and knowing that I'm speaking to a law professor, I am concerned more broadly about what I consider sort of a pattern of nullification. If there's a law we don't like, well, maybe we can't get it overturned, there seems to be efforts to defund it or even shut down government. Or in this case, what I would call the decapitation strategy. If you don't like the National Labor Relations Board, just don't appoint people to run the business. Or the Bureau of Alcohol, Tobacco, and Firearms, or in this case, the D.C. Circuit. The D.C. Circuit has an allotted number of judicial positions. This isn't something that the President chooses. Congress sets it on the advice of the Judicial Conference. The Judicial Conference has not suggested that the number should be shrunk. There are 11 judges, and 3 are currently vacant. The strategy of blocking appointments is sort of a nullification of law, which I think is troubling. But let me get to the question, Madam President, of what I consider to be a double standard that is blocking some wonderful candidates from going on to this court. My legal practice for 17 years was in the civil rights area. And in the civil rights area, there's a legal notion called a pretext. When something bad happens, you don't get an apartment, or you don't get a job, or you don't get your bank loan or your homeowner's insurance policy. And if a reason is asserted for that, but the reason just falls apart, it's just completely illogical, it's not borne by the facts, and that's called a pretext. And I worry in this instance that there's a couple of pretexts going on. Because the instances that have been cited by my colleagues, the filibustering of Caitlin Halligan, the filibustering of Patty Millett, and now the filibuster of Nina Pillard, rely really on 2 pretexts, and let me kind of go after them. The asserted reason, why are these candidates, Caitlin Halligan, who practiced before the U.S. Supreme Court, was the Solicitor General for the state of New York, did such a good job, why block her? Why block Patty Millett, who worked in the Solicitor General's office under both administrations, supported by Solicitor Generals of both administrations? Why block Nina Pillard? Nina Pillard was the appellate attorney before the United States Supreme Court to argue for the need to admit women students to the Virginia Military Institute in my state, which they have done, and it's working very well. One of Nina Pillard's supporters was the superintendent of VMI that was being sued. Cy Bunting has come forward and said Nina Pillard would be a great circuit justice. So what is the reason that's being asserted to block these 3 women? Well, the reason that's asserted is there's not enough of a workload on this court. And, Madam President, I think it's clear that the asserted lack of workload is a pretext. It's non-existent. It's a phantom argument that just gets brought up whenever we want to, but then abandoned whenever we want to. My evidence for that is pretty clear. There are 2 circuit courts, the 8th and the 10th Circuit, that have lower workload, lower caseload per judge than the D.C. Circuit. But we've been approving nominees to that circuit this year without raising any question about workload. So we will put folks on the 8th and 10th Circuit, even though they have lower workload and no one complains, the other side doesn't raise that. And I asked members, why are you raising that here when you weren't raising it on other courts? And they said, well, it's because the D.C. Circuit is the 2nd highest court in the land. It's a more important court. The phrase that was used by someone to me, it's a court that's got more juice. Members on the D.C. Circuit might be on the Supreme Court. So the workload isn't really the issue on the other courts. It's just an issue on this court, apparently because the court is so important. Well, let's now drill down on what's happened, Madam President, just this year. You and I are freshmen together. We came in on the 3rd of January 2013. We came in with a pending nomination of Caitlin Halligan for the court's supremely qualified, bipartisan support in the legal profession for her. She was filibustered, and one of the principal asserted reasons was there's not enough workload on the court. So she couldn't even get an up or down vote. Within 2 months, we had another nominee, a superbly qualified nominee, I might add, who I introduced before the Judiciary Committee, Sri Srinivasan. And we approved him, Madam President, in the Senate, 93-0. Now, he's a male. No one raised one question or mention of the workload on the D.C. Circuit. We had just turned down Caitlin Halligan because you don't get an up or down vote because there's not enough workload. But within 2 months, a 93-0 vote, we confirmed. And again, I want to make clear, I'm saying Judge Srinivasan, very qualified to be on this court. But the workload rationale just disappeared. But it didn't go away, because as soon as Patty Millett is nominated, as was indicated, not only a superb appellate attorney who's argued more cases before the Supreme Court than all but a handful of women in the history of this country, who's argued cases before the D.C. Circuit, where we hope she will sit, and other circuits as well. As soon as Patty Millett is nominated, well, the workload issue pops back up. The court doesn't have enough workload. And now Nina Pillard is being told that she's going to be blocked also because the court doesn't have enough workload. I assert that this workload issue is a complete pretext. It's not raised about other courts, and it's not raised about other nominees. Even this year it hasn't been raised, but it has been raised with respect to three superbly qualified women, Caitlin Halligan, Patty Millett, and Nina Pillard. And so that, as I just watched that, and I've only been here 11 months, I don't know all the prehistory, but I just watch it, the women candidates are being treated differently on this court, this second highest court in the land, this court that's, got kind of juice from which people may go to the Supreme Court. The women candidates are being treated differently. They're being blocked by concerns about workload that are not being applied in an even-handed way. And, Madam President, the last thing I'll say is just another bit of evidence that I think it's fair to put on the table in this question of whether there's a double standard for women. During the presidency of President Obama, there has also been the nomination of two women to be on the United States Supreme Court. Everyone knows this well. These were debates we followed, and also these two women, Justices Sotomayor and Kagan, enormously qualified, with bipartisan support from bar associations and others. Justice Sotomayor, when her vote was finally held here, more than 75% of the senators in the minority party voted against her confirmation on the Supreme Court. Elena Kagan, when she was up for nomination, 88% of the members of the minority party voted against her confirmation to be on the Supreme Court. Now, we could look at courts that aren't the two highest in the land and see there have been more appointments of women judges, and that's a good thing, and I hope there are more still. But when you get to the D.C. Circuit and the Supreme Court, it seems like there's a double standard. It seems like this phantom workload issue gets raised when it suits one side and then immediately dropped a couple months later, only to be raised again to block women candidates. And I think that is a very, very serious concern. Congress set the law that there's 11 judges on this court. The President is trying to comply with the mandate of Congress and putting well-qualified women before this body. And we should debate their qualifications, and if folks have concerns about those, well, then let's have that debate. But we shouldn't block them from being considered and assert reasons that don't stand the light of day. Thank you, Madam President. I re-yield the floor.
President.
Senator from Minnesota.
Well, I thank my colleague from Virginia for his well-thought-out argument and the evidence he put out here before the President, a former law professor, who believes in evidence, and I think it's important that we look at the facts here. And I wanted to back up, before I know the senator from Washington is here, but back up some of the facts for why this workload argument really doesn't make sense, even when it's put out clearly for the women nominees, and it wasn't put out recently for the male nominees. But here's the facts. When George W. Bush was president, the Senate confirmed his nominees to fill 4 empty seats on the D.C. Circuit. That wasn't that long ago. Under President Obama, there have been 4 vacant seats on the court. There were 4 under Bush and 4 under Obama. The difference? President Bush's nominees, all of them, were confirmed by the United States Senate. Now, it's important to note that one of President Obama's nominees, as was pointed out by my colleague from Virginia, was confirmed by the Senate, a guy. And I guess that means that one guy is confirmed, and then these 3 seats are still open for which women have been put forward. Some people apparently think that there's a problem with this, with the numbers, but let's look at the actual numbers. The individuals, these same people have supported having more judges on another court that actually has fewer pending cases. And the reason we use that standard pending case is that that is the active cases. They're not the pro forma orders that are issued quickly. These are the actual cases before the court where they have to make difficult decisions. The D.C. Circuit has 8 active judges, 6 partially retired senior judges, and 1,479 pending cases. The 10th Circuit has 10 active judges, 10 senior judges, and 1,341 pending active cases. So the 10th Circuit, which my colleagues have confirmed multiple nominees, has more judges but fewer pending cases per judge. Why does the 10th Circuit have more judges with fewer cases per judge than the D.C. Circuit? Well, to me, the answer is quite simple. Earlier this year, the Senate confirmed 2 judges to fill the empty seats on the 10th Circuit, and the Senate should do the same with the D.C. Circuit by taking these 3 well-qualified nominees and confirming them. With that, I see the senator from Washington has arrived, and I know she has a few remarks about this as well. And as I've pointed out to you, Madam President, this is just the beginning, that we are going to continue the fight for these 3 women judges.
Thank you, and I thank the senator from
Washington.
Thank you, Madam Chair. I thank the senator from Minnesota for her leadership out here on the floor this afternoon, and it's great to join her and my other colleagues to come out and talk about the importance of judicial nominees, and particularly today because we're talking about the nomination of more female representation on the courts, which I think is incredibly important. You know, I served my first 2 years here in the Senate on the Judiciary Committee, and I was struck to find that I think at that time may have been like the 4th woman in the whole history of our country to be on the Judiciary Committee, and now I'm so proud that my colleague from Minnesota serves on that committee and does an excellent job, and that we have other representation as well. But the point is, you know, you have to ask yourself, we need to get women elected. Do we have to get women elected to the United States Senate, to get women on the Judiciary Committee, to get women on the courts? Because our colleagues aren't going to help us do that. I'm rising today to support moving these nominations. President Obama has nominated Cornelia Pillard and Patricia Millett, and we want to see these vacancies filled. We don't want the same dysfunction that led to a government shutdown to let us move towards a kind of a stopping of putting people on the court. Nominating highly qualified individuals is what the president's job is, and filling seats on the court is not packing the court. It is simply doing the job. On October 31st, 2013, many of my colleagues voted against a motion to end debate on Patricia Millett to be a judge on the U.S. Court of Appeals for the District of Columbia. And she is a very highly qualified attorney who has argued before the Supreme Court 32 times and is recognized both by Democrats and Republicans for her legal acumen. But despite her qualifications, her nomination is being blocked. Had she been confirmed, she would only be the 6th woman to sit on the D.C. District Court of Appeals. So I'm questioning why we're at the place that we are now on this nomination. Professor Nina Pillard is another filibuster nominee who's argued historic cases before the Supreme Court, including a case to open up the Virginia Military Institute to women for the first time in history, and a case defending the family and medical leave law. The American people want to know, why are these qualified female judges being blocked? Just 32% of the U.S. appeals court judges are women. So in my opinion, it's time to move forward with more highly qualified nominees to add diversity to the courts. I've not heard any of my colleagues question the credentials of these nominees. In fact, Ms. Millett has been called, quote, a brilliant mind, a gift for clear, persuasive writing, and a genuine zeal for the rule of law. So this is not a quote that I just read by a Democratic senator or a liberal think tank. That quote is from former Special Prosecutor Kenneth Starr in a letter with 6 other Solicitor Generals, top lawyers who've served in both George H. Bush and George W. Bush and Clinton administrations, basically saying, quote, equally important, she is an unfailingly fair-minded, end quote. That is from Mr. Starr. So the D.C. Circuit Court currently has 4 judges chosen by Democratic presidents and 4 by Republicans. There are 3 vacancies on the court, and Republicans are arguing that to fill these vacant seats, that we shouldn't do that, just eliminate them. And I think my colleague from Minnesota just spoke to this. This is a proposal that is even opposed by Chief Justice John Roberts, who argues that the D.C. Circuit Appeals is like many of the federal courts and is operating in a state of crisis. So he said, quote, based on our current caseload methods, the D.C. Circuit Court should continue to have 11 judgeships. So we need a court that is fully staffed. And the primary responsibility of this court is the handling of involving federal regulations on environmental safety, health care reform, and insider trading. So to me, we should trust that our judicial branch can nominate and get justices on the court that basically will look at the law and not party affiliation and stop obstructing people who I believe are qualified to be on the court. So I hope that we can move forward. Ms. Millett is the second female nominee opposed by Republicans after the nomination of Georgetown professor Nina Pillard was filibustered. However, she joins a long list of judicial nominees who happen to be female who've been opposed, not because of their qualifications, but because they were nominated by this president. And I will submit that list for the record, Madam President. So I hope that this discussion today points out the need that we need more women on the courts. And maybe we also need more women elected to the United States Senate so we can make sure that we get more women on the courts. But this is about today asking my colleagues on the other side of the aisle to look past this court. Do not try to diminish it by narrowing its focus. Get more people who will support qualified women so we can have the diversity in America that we need represented on our courts, even at the D.C. District Appeals level. I thank the President and I thank my colleague from Minnesota for arranging for all of us to be here today to share our views.
Madam President.
Senator from Minnesota.
Madam President, I think there are two interesting facts that Senator Cantwell brought up that I didn't know. The first was the percentage of women on those federal district courts, that it's still in the 30% range, 32% range. And the second was Justice Roberts' belief that, in fact, we should have judges that fill these seats. And I think it's interesting, I'd add to that, that Justice Roberts actually was on the D.C. Circuit. And I remember looking at the numbers that when he was confirmed to serve on the D.C. Circuit, there was actually less pending cases per judge than there are now, even if these vacancies were filled. And again, I keep bringing that up because it is the one and only argument that we keep hearing against these three women that we talked about today. One, Caitlin Haugen, who was already filibustered, stopped in her tracks despite trying, 3 or 4 times, never giving up, 1 year, the next year, putting her name, having to go through a nomination process. And what we just saw, Patty Millett, eminently qualified, filibustered, stopped in the door. I've never seen so many tweets about a judicial nominee. They're not always, that well known. But in her case, she's a hero of military spouses across the country who cannot believe that my colleagues from across the aisle would deny her that right to serve on our courts. And now we have a new nominee before us, Nina Pillard. Someone, as we noted, has been unanimously suggested for this job by the nonpartisan American Bar Association, someone eminently qualified, 9 Supreme Court arguments, someone who has so much respect from those that she mentors, from her colleagues, both Democratic and Republican. I see that the senator from Connecticut is here, another member of the Judiciary Committee. Thank you, Mr. President. I yield the floor.
Mr. President.
The senator from Connecticut.
Thank you, Mr. President. I want to thank my colleague, an esteemed lawyer and prosecutor herself, for her service on the judiciary, her dedication to the quality of our courts, and her bringing us together this afternoon to focus on a topic that I think perhaps is not uppermost on the minds of most Americans, not something they worry about when they're bringing their kids to school or fixing dinner at night, but it shapes the quality of our society. It assures the rule of law, and it guarantees that the courts of our country look like the people of our country. We're here because there are too few women as judges on our federal courts. They've been denied that opportunity, as for so long they were denied the opportunity even to practice law. And so we're here because this situation is unacceptable. The Senate cannot and should not continue to obstruct the appointment of qualified nominees, in this instance they happen to be women. And Nina Pillard, like Patty Millett, is eminently qualified, indeed distinguished, a candidate who fits the ideal profile. If you were designing and writing in the abstract the resume of a circuit court judge for the United States of America, it would be Nina Pillard. One of the tragic results of the obstructionism that we see in the appointment of judges nominated by the President is that the Senate is blocking women appointees to this court. The Senate has only confirmed one woman to the D.C. court in the last 19 years. During this same time period, 5 men have been confirmed to the D.C. Circuit Court of Appeals. In the court's entire history, only 5 women have been confirmed. These facts speak for themselves. Thanks to the leadership of President Obama and Chairman Leahy, the Judiciary Committee has been approving qualified women to take the men-only sign off the door at the D.C. Circuit Court of Appeals. But those women have been blocked by a minority of this body. There ought to be common ground that senators better have a good reason to block an appointment to the judiciary made by the President of the United States, which is his constitutional responsibility, just as it is ours to advise and consent, not simply blindly block a woman appointee. In 2005, the bipartisan Gang of 14 came together, and they agreed that a senator should vote against a nominee only in, quote, exceptional circumstances, extraordinary circumstances. The history of that agreement is pretty well known here, even though only a handful of the senators who joined in the agreement are still here. And its spirit and intent ought to guide us, even if it's not binding in letter. Its intent and purpose are as real now as they were then, to avoid the kind of nuclear approach, and it's called, I suppose, the nuclear option for that reason, because it would be so organically threatening to the civility and collegiality of this body if it is invoked. The approach should be, as a Republican member of that Gang of 14 said, that judges should be denied confirmation only in the event of, quote, a character problem, an ethics problem, some allegation about the qualifications of a person, not an ideological bent. If senators agree that only exceptional circumstances justify blocking a nominee, then clearly the 3 female nominees that have been nominated by the President ought to be confirmed by the Senate. Our country, and the legal profession specifically, has an unfortunate history when it comes to women. As I mentioned earlier, for generations, women were not even allowed to practice law. Only recently have they been afforded the opportunity to serve on the federal bench, despite their serving with extraordinary distinction when they were, in fact, appointed. And they are still woefully underrepresented. When women are denied an equal chance to serve on our courts, we are left with judicial bodies that fail to reflect the American people, fail to reflect their values and backgrounds, their aspirations and dreams, and, in fact, their talents and insights. An exclusionary federal judiciary makes a mockery of our nation's claim to equal justice under law. The excuse for blocking appointees is that the D.C. Circuit Court does not need more judges. I find this claim unpersuasive based on the workload of the court. We can debate, in fact, the numbers, but statistics in this instance fail to reflect the complexity and difficulty of the cases that come before this court. And the same senators who say that the caseload fails to justify appointments now gladly voted to approve John Roberts to the 9th seat on the court when the court had just 111 pending appeals per judge. It now has 182 appeals per active judge. The history here is that the Senate approved appointees nominated by George Bush to fill the 9th, 10th, and 11th seats on D.C. Circuit, the 3 seats that are vacant today. But this issue should not be about partisan politics. It should not be about which president made the appointments. It ought to be about the principle, and that is, if the workload is insufficient, the number of seats on the court should be reduced by legislation. The Congress should not refuse to fill vacancies when they exist lawfully and, in fact, when there is strong evidence that the workload justifies filling those vacancies. Nina Pillard is a civil rights icon. She is a public servant of extraordinary distinction. Ms. Pillard led the integration of women into the Virginia Military Institute. Her work led the Supreme Court to uphold Congress's ability to pass the Family and Medical Leave Act. Her academic work continues to identify common ground between liberals and conservatives that can allow for the protection of important rights. Some have said that she is a feminist. Well, the fact is, Professor Pillard believes that a woman's right to choose is protected by the United States Constitution. In other words, she believes in a judicial decision written by Justice Blackmun, for whom I clerked, which has been upheld repeatedly by the United States Supreme Court over 4 decades. It is embedded in our constitutional law as fundamental as the right of privacy is fundamental to our Constitution. I think that her merits more than justify her confirmation. There's no question that she has the talent and temperament, the intellect and integrity, the experience and the sensitivity to serve as one of our great judges on this Court of Appeals. I urge my colleagues to put aside the extraneous and irrelevant considerations that may lead them to oppose confirmation, and very simply to give their approval to a woman who will be a mentor and a model to so many other women now in law school or beginning their careers or even beginning their judgeships, and who one day will aspire to this kind of position and will see her example and ours in approving her as an inspiration to them in their careers. Thank you, Mr. President. I yield the floor. I suggest the absence of a quorum.
Clerk will call the roll.
Mr. Alexander.
negotiations represent an opportunity to achieve the goal that we, I think, share with Congress and obviously with our allies and so many others in the international community, which is to ensure that Iran cannot obtain and will not obtain a nuclear weapon. We need to pursue that diplomatic opening because it exists, and we need to take the steps necessary to test the theory that the new Iranian leadership and the old Iranian leadership is actually interested in abiding by its international obligations and doing so in a way that is verifiable and meaningful and transparent. If that does not come to pass, we will absolutely retain the right and believe it would be important to terminate any moderate sanctions relief that might take place and to even ratchet up sanctions if necessary.
Well, let me ask you about Bob Menendez, of course, the Democratic chairman of the Foreign Relations Committee. He says he doesn't understand why during this interim period for negotiations, Iran couldn't be asked simply to suspend all enrichment activities, not roll it back, not limit the number of centrifuges, but simply suspend it. And what Menendez is saying is that's what should happen before there should be any even limited rolling back. Does the White House disagree with Senator Menendez on this?
Well, I would say that we're not getting into specifics about the negotiations taking place in Geneva, as I noted at the top. I would say that the first step of this phased-in approach that we're talking about here would have the effect of halting the Iranian nuclear weapons program. Halting it, which means basically
all enrichment. I mean, the weapons program they deny they even have. It
would stop Iran's nuclear program from advancing for the first time in a decade.
From advancing, so it doesn't mean it stops the program, does it?
It stops it from advancing. So basically, when you talk about when we make
centrifuges are still spinning, they're still enriching.
I would refer you to IAEA and others on the technical means by which the halt is achieved. But I would tell you that when our intelligence community and other intelligence communities make assessments about how long, where they are in their program and how long it would take for them to develop a nuclear weapon and where they are in the process of enrichment, that all that progress would halt. And that essentially, by halting the clock and potentially rolling back where they are, puts time on the clock to allow for the pursuit of a more comprehensive agreement. If that can't be achieved, the moderate sanctions relief we're talking about here would be reversible, and we would be in a situation where, acting with the international community, acting with Congress, we could reinstate all of the sanctions and consider ratcheting up sanctions to increase pressure, because again, it's the approach that we've taken with regards to sanctions and the international consensus that we've built that has gotten us to this point already.
And can you remind me of what the end goal here is? Because it had, long been to stop all enrichment. Is that still?
No, our stated policy has always been that we will prevent Iran from obtaining a nuclear weapon.
What's our
The United States policy is to prevent Iran from obtaining a nuclear weapon. Our view is, as the President has said, with respect to the right of the Iranian people to access a nuclear program, that we respect that right. But what the specific of a peaceful nuclear program, what the specific nature of that program would be, is a matter for discussion and negotiation. So we respect the right of Iran to have a peaceful nuclear program. Our policy objective, which we share with our allies and everyone involved, obviously, in the P5
Dispense with the quorum call.
Without objection.
Thank you, Mr. President. We've been trying to figure out all day how to fit 5 numbers on this poster. I've been bringing it down nearly every week since the anti-gun violence bill failed here in the Senate due to a Republican filibuster, and this is the first week that this poster comes down to the floor of the House with 5 digits. 10,287 individuals, Americans, have been killed by guns since December 14th, the day of the Sandy Hook shooting. And, Mr. President, what I've been endeavoring to do since the failure of that bill on the floor of the Senate, despite the fact that 80 to 90% of Americans supported the bill, is to bring to this floor the voices of victims, because the statistics are numbing at this point. 10,000 people in this country have died at the hands of gun violence since December 14th. And that apparently has not been enough to move this place or the House of Representatives to action. So my hope is that by coming down to this floor every week or so and starting to tell the real stories, the human stories about the individuals who have lost their lives and the absolutely catastrophic runoff of trauma that happens to a family in a neighborhood, in a community when you lose a loved one due to gun violence, that maybe that will move this place to do something. And so I actually just want to tell 3 stories this morning because it now is kind of routine. You just sort of wonder what day of the week is it going to be when you turn on CNN or look at your Twitter feed and you see active shooting in progress, school lockdown, people fleeing airports. Just kind of happens every week now. It's just become kind of a commonplace occurrence, almost raindrops in the background of news coverage on a daily basis. This week's shooting, next week's shooting. On October 21st, a 7th grader named Jose Reyes, student at Sparks Middle School, opened fire with a handgun that he just took from his parents. He killed a teacher, he killed himself, and he left 2 other students wounded at a middle school in Nevada. The teacher he killed was named Mike Lansbury, and boy, you don't get much more American than Mike Lansbury. He was an Alabama native. He graduated from high school in Reno, which is right next door to Sparks, in 1986, and he went and served in the Marine Corps. He joined the Air National Guard after he got out of the Marine Corps, and he rose to the rank of Master Sergeant, and he served as a cargo specialist in Kuwait and Afghanistan. He fought for this country. He put his life on the line to defend this nation, and as happens with thousands and thousands of veterans, when he came back, he decided to continue his public service, in this case becoming an incredibly popular math teacher. His brother said of Mike, he's just the kind of person that if somebody needed help, he would be there. He loved teaching. He loved the kids. He loved coaching them. He was just a good all-around individual. But Mike is no longer, because he is now one of the over 10,000 Americans who have died at the hands of a gun, this time in a school shooting on October 21st. Gerardo Hernandez, according to his wife, was always excited to go to work. He was a joyful person who took pride in his duty for the American public. Gerardo was the TSA screener at Los Angeles Airport who was gunned down when Paul Ciancia, a troubled 23-year-old, walked into LAX with an assault weapon. And with a grievance and grudge against the government, opened fire, killing Gerardo Hernandez, age 39. He was the youngest in a family of 4 boys that had all emigrated from El Salvador. He was 15 years old when they made the decision to come to the United States to seek a better life, a safer life, a more stable life. And now the youngest of 4 boys is one of 10,287. And finally, Mr. President, the story of Maria Flores, who frankly didn't make headlines when she died over the summer along with her daughter Elizabeth Gomez. They died in Las Vegas when Manuel Mata, her boyfriend with a history of jealousy and domestic violence, shot and killed Maria, his girlfriend. He shot and killed her teenage daughter, and he wounded a 4-year-old before turning the gun on himself. Family members said that Mata had financial troubles, he drank often, he displayed jealousy, and he would constantly accuse his girlfriend of cheating. His girlfriend, Maria Flores, who died that day, they said, had threatened to move out of the residence a couple of weeks earlier, but she was convinced by Mata to stay. The daughter who was killed was scheduled to graduate 3 days after the murder took place. I tell these three stories for this reason. First, in the wake of the TSA shooting, a lot of people, a lot of folks from the gun lobby made the argument that the way to fix this problem was to just arm TSA agents. Just like people made the argument that the way to guarantee that another Sandy Hook happens is to just arm the teachers. Some people actually had the audacity to argue that actually an even better way is to just arm the students, too. And it speaks to this sort of new philosophy that has infested this place, Senate and the House, that I kind of describe as gun control Darwinism. The idea that if everybody has a gun, the good guys and the bad guys, that hopefully enough of the good guys will shoot the bad guys. You just throw a whole mess load of guns out there and let them figure it out, and in the end, we'll take care of the bad guys. We have some new data that tells us how backwards that philosophy is. Common sense tells you that's not a good idea, but the data now tells you that that's not a good idea. The American Journal of Public Health did the most comprehensive study ever done in this country, looking at rates of gun ownership and rates of homicide by gun death. They looked at decades of data across every state in the nation, and then they had the common sense to control for about every factor that you could think of: gender, race, poverty, income, education, alcohol use, crime rates. And what they found is pretty stunning and pretty straightforward. The American Journal of Public Health said that for every 1% increase in gun ownership in a particular state or locality or geographic region, there is a firearms homicide rate increase of 1%. A 1-to-1 ratio. Gun ownership goes up by 1%, increases in gun homicides go up by 1%. And police chiefs in city after city across the country will verify that. As they have taken guns off the street, as they have engaged in gun buyback programs, guess what? Miraculously, gun deaths decrease. Now, that's not to say that the only thing that matters here is the number of guns that are on the street. Clearly, this young man who walked into Sparks Middle School and the 23-year-old who walked into LAX had enormous issues that were going untreated. We're fooling ourselves if any of us are trying to perpetuate an argument that this is just about gun ownership. This is also about a very broken mental health system that we need to address. But a 1% increase in gun ownership leads to a 1% increase in gun violence. Less guns, guess what? Leads to less violence. And the reason that I tell Maria's story is because this is Domestic Violence Awareness Month, or maybe October was either completed it or in that month. And here's a stunning fact. In states that have comprehensive background checks, women are 38% less likely to die from domestic violence crimes. Women are 38% less likely to die from domestic violence crimes if they are lucky enough to live in a state that says before you buy a gun, you have to prove to us that you aren't a domestic abuser. Since 1998, 250,000 domestic abusers have been stopped from buying guns because of background checks laws. And that's just the domestic abusers who were dumb enough to show up at a gun store and try to buy a firearm. That doesn't count the, frankly, millions of domestic abusers who never walked into the store to buy the gun in the first place because they knew they were going to be denied. Women in the United States are 11 times more likely to be murdered by a gun than women in any other high-income nation. And we have a solution. Background checks. 40% less likely to die from domestic violence if you live in a state with a background check. And so, Mr. President, I bring just 3 stories to the floor today in my effort to bring voices to the victims, those of Mike, a teacher in Nevada, Gerardo, an immigrant to this country who loved doing his public service as a TSA screener, and Maria Flores, one of thousands of women across this country being killed by their spouses or partners because, in part, of the ease of access to a gun in this country. 10,287 people, tough to fit on one sheet. That's just in 11 months. It frankly won't take that long, just a handful of years from now, before there is absolutely no way to fit this number on this board, unless the United States Senate and the House of Representatives decides that 90% of Americans are right, and we should make sure that criminals can't access guns. We should ban illegal gun trafficking. We should expand the reach of our mental health system so that we can finally say that Congress, the Senate, and the House is going to do something to give voice to these victims. Mr. President, I yield the floor and note the